¿Puede la guerra tener límites? Una pregunta milenaria que busca luz en la oscuridad del conflicto. Desde la Parashat Ki Tetzé hasta la creación de los derechos humanos, hemos intentado trazar fronteras morales en el campo de batalla. Porque incluso en la guerra, la ética reclama su lugar. ¿Cómo establecer límites donde parece no haberlos? Descubremos hoy qué dice la Torah sobre la guerra.
Shalom, shalom, and welcome to your channel, La Mishnah TV, where this week we will study Parashat Ki Tetzé from the book of Deuteronomy. And, as is our custom, we will begin with a question that makes both the believer and the skeptic uncomfortable. And perhaps that is precisely why we must ask it. How can the very same Torah that commands us to love the stranger, protect the weak, and pursue justice also contain holy wars, the enslavement of the defeated, and mandates that, when viewed through the lens of our own moral sensibilities, are deeply disturbing? Must we defend the text at any cost? Must we condemn it from the perspective of the 21st century? Or is there a third possibility, one that is far more difficult and far more interesting? To study it with honesty? For this is where our problem begins. Ki Tetzé opens with a captive woman and ends with Amalek. This does not seem like a coincidence. Between these two extremes lies an extraordinary collection of laws designed to restrain the powerful, the soldier, the husband, the father, the creditor, the employer, the judge, and even the property owner. It is as if the Torah were posing a disturbingly modern question. What happens to morality when one person holds power over another? And specifically, what happens to morality during a war? For declaring war is one thing. Deciding what may be done within it is quite another. Today, international law distinguishes, among other categories, between jus ad bellum, the conditions for the legitimate use of force, and jus in bello, the rules governing conduct during the conflict. The Torah, evidently, was unfamiliar with these Latin terms or the Geneva Conventions, but it was certainly familiar with the problem. And here, we must avoid two equally tempting errors. The first is to triumphantly claim that the Torah invented international humanitarian law. Historically, that position is untenable. The second is to read Deuteronomy as if it had been written after Auschwitz, Hiroshima, and the founding of the United Nations. That, too, would be an anachronism. Our task will be a more uncomfortable one, and precisely for that reason, it will be intellectually more serious. We will enter the biblical world before passing judgment on it. We will study the true meaning of Hebrew expressions such as Yafat Tu'ar, the captive woman, Herem, consecrated destruction, Melhemet Mitzvah, obligatory war, Melhemet Rezhut, discretionary war, Bal Tashet, the prohibition against unnecessary destruction, and Zeker Amalek, the memory of Amalek. But then, something even more interesting will happen. We will discover that there is no single Jewish position on war. The Mishnah interprets. The Talmud debates. Halakhic midrashim define the boundaries. Rashi explains. Ramban disagrees. And Ramban provides a legal systematization of a tradition that had already spanned centuries of interpretation. In other words, Judaism did not merely inherit difficult texts. It also inherited the obligation to debate them. We will then place this tradition alongside another conversation, modern biblical criticism. We will discuss composition, the ideology of conquest, collective memory, gender, imperial politics, and the Neo-Assyrian context. Not to destroy faith, nor to artificially protect it, but rather to understand the nature of the documents we are reading and the questions they sought to answer within their own world. Finally, we will arrive at the present day, the distinction between combatants and civilians, proportionality, precaution, military necessity, humanity, individual responsibility. Only then can we seriously formulate the comparison. Which elements of biblical law can be considered antecedents within the long intellectual genealogy of the laws of war, and which belong to a radically different moral and legal universe? For the thesis we are about to explore is provocative. The Torah can limit violence while simultaneously legitimizing forms of violence that we reject. It can humanize certain aspects of war without thereby becoming a pacifist treatise. Both statements can be true at the same time, and enduring that tension is precisely what distinguishes serious study from propaganda. That is why the question running through this entire masterclass will be simple to ask, yet extraordinarily difficult to answer. Does the Torah humanize war? Does it legitimize it? Or does it do both at once? Let us not seek a comfortable answer. Let us seek an answer that can withstand the text, history, and our own conscience. For perhaps the great lesson of Ki Tetzé is not that power can become pure. Perhaps it is something far more realistic, that even when we believe we have grounds to use force, we remain responsible for what that force can turn us into. And that conversation began thousands of years ago. But regrettably, it has not yet ended. This is Abel Flores, founding journalist of La Mishnah TV. Thank you very much for studying with us. And before we begin the class, I'd like to remind you to please subscribe to our channel and hit the like button if you haven't already. I also invite you to visit our website, lawmishnah.com, where you'll find plenty more content on all these topics, including articles, features, and our renowned course covering the entire Mishnah from start to finish in your language. Let's get started. There is a literary detail in Ki Tetzé that might go unnoticed, yet once discovered, it transforms the way we read the entire parasha. Ki Tetzé begins with Israel holding power over a vulnerable person, and it concludes by recalling what happened when another nation held power over the vulnerable among the people of Israel. Between those two scenes lie 74 commandments. Parashat Ki Tetzé spans Deuteronomy chapter 21 verse 10 through 25 verse 19, and according to traditional counts, contains more commandments than any other parasha asterisk in the Torah. Yet its structure is even more intriguing than the sheer number of laws it contains. The opening words are Ki Tetzé lemilchama al oivecha, when you go out to war against your enemies. This phrasing echoes, almost verbatim, Deuteronomy chapter 20 verse 1, which was read in the preceding parasha, Shoftim, when you go out to war against your enemy. Liturgically, we close one parasha and begin another. Literarily, however, the text has not necessarily shifted the conversation. Deuteronomy chapter 20 governs the public dimensions of warfare: who fights, who is exempt, how peace is proclaimed, how a siege is conducted, and what may be destroyed. Then comes Ki Tetzé, and something extraordinary happens. War crosses the threshold of the home. The battlefield becomes the bedroom. The asterisk Yafat Toar, the captive woman of beautiful appearance, enters the scene. And with her arises a far deeper moral question. What happens when the fighting ends, yet the absolute disparity of power between victor and vanquished remains? The Torah seems to compel us to recognize that violence does not necessarily cease when weapons are laid down. It can persist within human relationships, in marriage, in the family, in the economy, in the workplace, in the courts. That is why Ki Tetzé contains laws regarding wives, children, debts, wages, property, sexuality, justice, and the protection of the vulnerable. The central issue begins to emerge. What does a society do with the power it holds over others? And so we arrive at the end of the parasha. Deuteronomy 25 commands, asterisk Zahor et asher asal laha Amalek. Remember what Amalek did to you. And what did Amalek do? The text emphasizes something chilling. It attacked precisely those who were lagging behind, weary and weakened. Amalek used its strength against those least able to defend themselves. Now, let us look at the overall structure. At the beginning of Ki Tetzé, Israel is the victor, and a foreign woman is in its hands. At the end, Israel recalls the moment when its own vulnerable people were in the hands of an enemy. It is almost a moral mirror. At the start, you are strong. At the end, remember what it feels like to be weak. And between these two extremes appeared dozens of commandments seeking to regulate human conduct where there is an imbalance of power. Here lies one of the keys to understanding Ki Tetzé. The question is not merely how we should behave when we are the victims. That is relatively easy to answer. The truly difficult question is how we should behave when we are the ones who can decide another's fate. For a person's morality is not revealed solely when they lack power. It is also revealed when they could abuse that power yet choose to restrain themselves. Perhaps that is why Ki Tetzé begins on a battlefield and ends with the memory of Amalek, to remind us of something uncomfortable and deeply relevant today. Never forget what was done to you when you were vulnerable. But also, Never forget who you might become when the vulnerable are in your hands. When we think about the biblical laws of war, we often imagine that the Torah contains a small military manual. But something much more interesting happens. The rules are distributed among institutions, soldiers, enemy cities, captives, families, and even trees. And this dispersion reveals a fundamental idea. War is not only a military event. It is a situation in which human power becomes extraordinarily dangerous. Let's start with Deuteronomy 17 verses 14 to 20. Before regulating the army, the Torah regulates the king. The monarch must not excessively multiply horses, women, or wealth, and must remain subordinate to the Torah. This matters because, in the ancient Near East, the king was usually the one who concentrated political and military power. The message is provocative. Before limiting the war, we must limit who can decide it. Then we come to Deuteronomy 20 verses 1 to 9. Here we find the priest who speaks before the battle, strengthens the spirit of the combatants, and reminds that Israel should not depend exclusively on its military capacity. But famous exemptions also appear. Whoever built a house and hasn't opened it yet can return. He who planted a vineyard and has not yet enjoyed it can return. Whoever got engaged to a woman can return. And those who are afraid also appear. Military mobilization, therefore, does not automatically absorb all human existence. Deuteronomy 20 verses 10 to 20 then changes the scene. Now we are facing the enemy city. The offer of peace appears, the conditions of surrender, the siege, and also one of the most difficult concepts of our entire class, Jerem, the consecrated destruction applied in certain texts to the Canaanite populations. We must not soften it. The same chapter that establishes restrictions also contains mandates that are morally inadmissible from contemporary categories. And precisely here the serious study begins. In the midst of the siege, a surprising limitation also appears, Bal Tashjit, the prohibition of destroying fruit trees to use them indiscriminately against the city. Then, Deuteronomy 21 verses 10 to 14 introduces the Yafat Tor, the captive woman. The war now enters the sexual and domestic sphere. The text regulates her mourning, her incorporation into the house, and, if she is subsequently rejected, demands her release and prohibits selling it. Is this equality according to our criteria? Obviously not. Does it introduce restrictions on the power of the victor within its own context? That is precisely the historical question we must investigate. Deuteronomy 23 verses 10 to 15 takes us back to the camp. There we find norms of purity, behavior, and sanitation. The military camp is not presented as an area where morale is suspended because we are at war. On the contrary, it is considered a space where the divine presence demands discipline. Even something as seemingly everyday as human waste receives regulation. Holiness, we could say with some irony, also needs a shovel. Next, Deuteronomy 24 verse 5 states that the newlywed is exempt for 1 year. The family receives temporary priority over certain public obligations. And finally, we come to Deuteronomy 25 verses 17 to 19. Amalek. Memory, war, and justice meet there in an explosive formula. Amalek is remembered as the one who attacked the exhausted and vulnerable in the rear. But the mandate to erase his memory will later open enormous interpretive and ethical questions. And we still must face more severe texts. Numbers 31, about Midian, and 1 Samuel 15, about Amalek, speak of execution, captives, booty, and purification. They are not texts that we should hide. They are precisely texts that we must study. And academic precision is essential. Placing these units within the same thematic corpus does not mean affirming that they all emerged at the same time or necessarily belong to a single stage of composition. This will have to be discussed with biblical criticism. For now, let's look at the pattern. The Bible does not present war as a legal vacuum. It regulates the king before the battle, the soldier during it, the victor after it, the camp, the captive, the family, and even certain natural resources. But along with these restrictions, it preserves texts of extreme violence. And therein lies our real question. Not whether the Bible is simply peaceful or violent. That would be too easy. The question is how the same tradition could try to contain power and simultaneously sacralize some of its most terrible expressions. Understanding that tension will be essential to understanding everything that comes after. There is a mistake that can completely ruin our analysis of the biblical laws of war, lumping all questions into a single category. Asking who may initiate a war is not the same as asking what may be done during it, or what a society must remember once the war has ended. These are three distinct issues, and if we conflate them, we risk attributing legal concepts to the Torah that did not yet exist. The first aspect concerns the cause and authority of the war. The Torah does not develop a systematic theory equivalent to the modern jus ad bellum, that is, the set of legal criteria governing when force may legitimately be used. We find something different. The Bible recounts defensive wars, wars of conquest, and wars presented as directly commanded by God. Deuteronomy presupposes the legitimacy of certain campaigns because they are linked to two fundamental elements of its theology, the divine command and the promise of the land. That is why we must be careful. Moses is not reading the United Nations Charter in the desert. Applying contemporary categories directly to the ancient text may be appealing, but historically it would be an anachronism. Later rabbinic tradition would do something different. It would take that biblical diversity and begin to organize it legally. Categories such as *milhemet mitzvah, obligatory war, and *milhemet reshut, discretionary war, would emerge, alongside discussions regarding who holds the authority to launch specific campaigns. That development would prove fundamental later on. The second aspect concerns conduct during the war. Here we find the functional parallel closest to the modern jus in bello. I emphasize, a functional parallel, not a historical identity. The Torah establishes genuine restrictions. We find provisions for peace offers, military service exemptions, camp discipline, limits on certain forms of destruction, rules for sieges, and regulations concerning captives. This means that a war deemed legitimate does not automatically legitimize everything the victor might wish to do, and that distinction is extraordinarily important. It is one thing to believe you have the right to fight. It is quite another matter to believe that simply because one possesses that right, limits no longer exist. Yet we must not prematurely turn these biblical norms into the Geneva Conventions. The protected subjects, legal categories, moral foundations, and the scope of obligations differ. To compare is not to equate. We now arrive at the third level, perhaps the most psychologically perilous one, memory in the aftermath of war. Here, Amalek enters the picture. Zahor et asher asa lecha Amalek. Remember what Amalek did to you. The war has ended, but the memory remains, and that memory transforms into identity, intergenerational obligation, liturgy, and public reading. This introduces a fascinating problem. Wars may end militarily, yet continue to live on within a people's imagination. The historical enemy can become a symbol, and that symbol can transform into a typology. Amalek ceases to function merely as a reference to an ancient enemy and begins to serve, in certain interpretive contexts, as a paradigm of the enemy itself. Here, too, lies an enormous risk. When we automatically transfer a sacred category regarding an ancient enemy onto later adversaries, memory may cease to protect us from the past, and instead begin to reproduce it. That is why we must keep these three levels distinct. First, who authorizes the war, and why? Second, what actions are permitted during it? Third, what do we do with the memory of it once it ends? And here we find one of the exegetical keys to Deuteronomy. Deuteronomy does not eliminate war. It integrates it into the covenant. Precisely for this reason, an extraordinary paradox emerges. The divine presence functions simultaneously as both authorization and restraint. God fights on behalf of Israel, yet precisely because God is present, the camp must remain holy. War does not create a space outside the law. According to the text's internal logic, it produces the exact opposite. The more intense the presence of power, the greater the demand for discipline. And perhaps that is a lesson that transcends the ancient world. The true moral test does not begin merely when we ask whether we have the right to exercise power. It begins when, convinced that we possess that right, we still accept that there are things we must not do. If we were to look for something akin to a military constitution for Israel within Deuteronomy, chapter 20 would be one of our foundational texts. But a word of caution, we will not find modern pacifism there. We will find something more complex: authorized warfare, severe violence, and simultaneously limits imposed on military power. The chapter begins by confronting what terrified any ancient army: horses, chariots, and numerical superiority. The priest declares, Al tira mehem, do not fear them. Why? Because Hashem accompanies Israel. From a traditional reading, this strips technical superiority of its sacred status. Victory does not prove that Israel is invincible. It depends on God, and therefore should not breed arrogance. From a historical critical perspective, however, we are dealing with an ideology of divine warfare that constructs an identity in opposition to great military powers. It is not pacifism. Then something surprising happens. Deuteronomy chapter 20, verses 5 to 9, allows for the return of those who have built a house but not yet dedicated it, those who have planted a vineyard but not yet enjoyed its fruit, those who have become betrothed to a woman but not yet married her, and finally, those who are afraid and might spread that fear to others. House, vineyard, and marriage represent interrupted life projects. Curiously, Deuteronomy chapter 28, verse 30 turns these very images into a curse: building but not inhabiting, planting but not enjoying, betrothing and losing. Laura Quick has proposed reading these exemptions as a ritual intended to prevent that cursed frustration from affecting the army. Yet the rule serves a dual function. It protects human endeavors while simultaneously safeguarding military effectiveness. The Mishnah complicates the picture even further. Mishnah Sota 8.7 establishes that in a certain category of obligatory war, everyone goes out, even the groom from his chamber and the bride from her canopy. Thus, these exemptions do not function as absolute rights. They depend on the legal classification of the war. We come then to the famous offer of peace. Deuteronomy chapter 20, verse 10 commands that peace be proclaimed before attacking a distant city. It sounds remarkably modern, until we read further. If the city accepts, it becomes subject to tribute and forced labor. If it refuses and is conquered, the men are executed, while the women, children, and possessions become spoils of war. We must therefore state this precisely. Offering peace here does not mean negotiating between equal sovereign states. It means offering terms of surrender before battle begins. Maimonides would later expand upon this principle. In Hilkot Melachim 6:1-5, he upholds the offer of peace for both obligatory and voluntary wars, including the legal treatment of the Canaanites and the Amalekites, subject to conditions of subordination, tribute, and acceptance of the Noahide laws. Then we encounter one of the most morally challenging texts. Deuteronomy distinguishes between distant cities and the Canaanite peoples of the Promised Land. For the latter, it prescribes harem. The term denotes something set apart from ordinary use and irrevocably dedicated to God. In a military context, it can imply total destruction. From the perspective of contemporary law, killing based on collective identity is incompatible with fundamental principles such as distinction and individual responsibility. Furthermore, it conflicts with the prohibition against genocide when the legal elements of that crime are present. We must not sugarcoat it. Historical criticism, however, asks a different question. Are we truly looking at a transparent chronicle of a total conquest? Archaeology, internal tensions within the biblical narratives themselves, and studies on the composition of Deuteronomy have led many scholars to interpret this program as an ideological construct projected into the past and linked to religious exclusivity. That may explain the text historically. It does not automatically resolve the moral issue it presents. Finally, we come to the trees. During a prolonged siege, Deuteronomy chapter 20, verses 19-20, forbids the destruction of fruit trees, though it permits the use of other trees for military works. From this, the principle of Bal Tashit, do not destroy, would develop. Maimonides would vastly expand its scope. The unnecessary destruction of food, utensils, clothing, buildings, or water sources could fall under this prohibition, though he allows for destruction when there is a genuine need or a greater utility. There is scholarly debate even on this point. Neeli Wazana links the text to Neo-Assyrian military practices and propaganda, in which the devastation of orchards could serve as an expression of imperial domination. Jacob L. Wright questions whether that polemic alone explains the rule, emphasizing instead the practical logic of military necessity during a siege. And thus, we can understand the paradox of Deuteronomy chapter 20. The very chapter that permits violence we would consider unacceptable today also insists that the war does not make everything permissible. That will be one of the great principles of our class. Being convinced that a war is legitimate does not mean receiving a moral blank check, for it is precisely when human beings possess the power to destroy that the most difficult question of all arises. What do they choose not to destroy? There are Torah texts we can study comfortably. This is not one of them. Deuteronomy chapter 21, verses 10 through 14, compels us to enter a situation where war, sexual desire, captivity, and male power converge in the same space. The sequence begins after a battle. Israel takes captives. A soldier spots a woman of *Yefat Toar, beautiful appearance, among them, and desires her. But the text introduces a procedure. He must bring her into his home. She alters her hair, her nails, and the attire associated with her captivity. Then she remains there for a month, mourning her father and mother. Only then can the union take place, and she acquires the status of a wife. And if the man later ceases to want her, a decisive restriction applies. He must set her free. He cannot sell her. He cannot turn her back into a commodity. The reason? Tahat asher inita, because you have afflicted, humiliated, or subjugated her. That verb, inna, is significant because it prevents this story from being turned into a biblical romance. Suffering is present here. In the *peshat, the most direct contextual reading, the month-long period seems to create a distance between the victor's immediate desire and the sexual act. The captive ceases to function as anonymous spoils of war and enters into a domestic and legal process. But we must immediately state the other side of the matter. The text does not explicitly ask for her consent. She remains a captive within a power structure created by war. Therefore, viewed through our contemporary categories, there is a fundamental problem in speaking of truly free consent. Furthermore, several Hebrew expressions are ambiguous. And you shall take her for yourself as a wife can be understood as a legal consequence. If you desire her, you cannot simply use her sexually and abandon her. You must enter into a marital relationship that entails obligations. The expression regarding her nails has also sparked debate. Must she cut them or let them grow? The Midrashic tradition, followed by Rashi, interprets these actions as a deliberate way to diminish her attractiveness and dampen the soldier's desire. The month-long period, then, can serve several simultaneous functions: genuine mourning for her, a transition of identity, and a deterrent mechanism for him. And here, an extraordinarily revealing rabbinic interpretation emerges. Kiddushin 21b states, Lo dibara Torah, ella keneged yetzer hara. The Torah spoke only in response to the evil inclination. In other words, the rabbis do not present this scene as a romantic ideal. They interpret it as a regulated concession in the face of a dangerous desire. Rashi even draws a narrative connection between the captive woman and the laws that follow, the unloved wife and the rebellious son. The message is devastating. That which is technically permitted can set a tragedy in motion. But there is an even more uncomfortable discussion to be had. Rabbinic sources are not uniform regarding the initial sexual act. One line of interpretation, associated with the Jerusalem Talmud and consistent with a sequential reading of the passage, holds that no sexual relations take place prior to the month-long period and her integration. The Babylonian tradition, later codified by Maimonides in Hilkot Melachim 8:2-6, permits an initial act under certain conditions while she is still a Gentile, should the soldier be overcome by impulse. However, it forbids abandoning her and restricts any further relations prior to the marriage process. We must not shy away from what this implies. By contemporary standards, a sexual encounter with a captive woman who lacks effective freedom constitutes sexual violence. Acknowledging that ancient legislation introduces restrictions does not mean artificially transforming it into modern ethics. And here we must hold two truths simultaneously. First, in a world where captive women could be raped, exploited, turned into concubines, or sold, Deuteronomy introduces a waiting period, mourning, obligations, and ultimately a prohibition against resale. Second, the woman remains within a patriarchal and coercive system that does not embody our concept of sexual autonomy. Carolyn Pressler has pointed out precisely this tension in the family laws of Deuteronomy. There are mechanisms to protect dependent individuals within a domestic structure that remains hierarchical. For this reason, calling this rule simply anti-rape legislation can be misleading. It may represent an ancient restriction against immediate exploitation, but if that term causes us to overlook the captivity, the inequality, and the absence of autonomous consent, then we have modernized the text rather than understood it. And perhaps this is the most uncomfortable lesson. The Torah does not always begin by completely transforming the world it regulates. Sometimes it begins by setting limits within that world. Our responsibility as readers is to recognize those limits without turning them into something they historically never were. There is a phrase in Deuteronomy that may seem religious and ceremonial, yet it contains an extraordinarily modern psychological insight. Ki Adonai Elohecha, mithalej bekerev majanecha. For Hashem, your God, walks in the midst of your camp. Deuteronomy chapter 23 commands the army to guard itself against anything evil. Anyone who experiences a nocturnal emission must temporarily leave, bathe, and return at nightfall. Furthermore, bodily functions must be attended to outside the camp, and every soldier must carry a tool to dig and cover his excrement. Today, our immediate thought is military hygiene, and certainly there are obvious sanitary benefits. But it would be anachronistic to imagine Moses explaining microbiology 3 millennia before Pasteur. The text's explanation is theological. God walks within the camp. Therefore, there must be purity, decency, and discipline. Moreover, excrement does not typically function in the Torah as an automatic source of ritual impurity. The passage combines different categories: the impurity linked to seminal emission, and the indecorous nature of exposed waste. Qumran would take these concerns toward a rigorous discipline of communal purity. Rabbinic tradition, for its part, would project similar principles onto the spaces appropriate for prayer and Torah study. But Ramban discovers something even deeper here. When a person goes out to battle, he explains, even someone normally righteous can become cloaked in cruelty and rage. War removes inhibitions. Actions we would never take at home may begin to seem acceptable when facing the enemy. That is why guarding against anything evil can encompass theft, looting, brutality, and sexual abuse. Military holiness, then, does not consist solely of maintaining a clean camp. It consists of preventing war from morally defiling the combatant. Deuteronomy chapter 24 verse 5 introduces another surprising limit. A newlywed man is exempt from military service and certain public obligations for a year so that he may bring joy to his wife. This rule elaborates on Deuteronomy chapter 20 verse 7. In a society where lineage, inheritance, and domestic stability were paramount, the state, to use our terminology, could not automatically subsume all private life. Yet this exemption was not absolute. The Mishnah would later restrict it in the case of certain obligatory wars. The tension is clear. The Torah safeguards the building of civil life, while tradition acknowledges situations where collective survival may supersede individual interests. A verse later, another decisive principle emerges. Ish biyeto yumatu. Each person shall die for his own sin. Deuteronomy chapter 24 verse 16 belongs to domestic criminal law, not to the modern law of armed conflict. We must not artificially turn it into a rule governing military attacks or incidental damage. Yet it does establish a powerful framework of individual responsibility. Guilt should not be automatically transferred from parents to children. And this prepares us for an immense tension. Amalek. Deuteronomy 25 recalls that Amalek attacked precisely those among the Israelites who were exhausted and straggling behind. The moral indictment centers on the act of attacking the vulnerable. But then a paradox arises. Zachor, tinje, lo tishkach. Remember, you shall blot out, do not forget. Remembering in order to blot out, and not forgetting that we must remember. Tradition would transform this memory into liturgy, most notably through Shabbat Zachor. Maimonides codifies both the duty to remember Amalek's hostility and the commandment to fight against it. Yet within his broader system, he also establishes that peace must be offered before war under certain conditions. Later interpretations would further limit the historical applicability of Amalek. Some would argue that identifying them ethnically is no longer possible. Others would transform Amalek into a symbol of radical hatred, or even of inner evil. These interpretations are significant, but we must not use them to retroactively erase the stern meaning of the biblical text. And herein lies a fundamental contemporary warning. Automatically equating a current political adversary with Amalek is hermeneutically dangerous. For when the enemy ceases to be a specific individual and becomes a metaphysical embodiment of evil, concepts such as individual responsibility, distinction, and proportionality can begin to vanish. Contemporary law demands far greater precision. Liability for genocide hinges on facts, context, and the specific legal intent to destroy, in whole or in part, certain protected groups. A biblical reference, standing alone, does not establish such liability. Finally, we must consider texts that preclude any overly comfortable reading. Numbers 31 depicts the war against Midian, including executions, captives, the division of spoils, and purification. 1 Samuel chapter 15 presents the asterisk harem against Amalek as applied to human beings, humans, and animals. We cannot hide these chapters behind Bal Tashit, the protection of trees, or the offer of peace. Susan Niditch has shown that the Hebrew Bible preserves various models of warfare. Harem, understood sacrificially, war by divine command, pragmatic warfare, and narratives built around heroic honor. C.L. Crouch, comparing Israel, Judah, and Assyria, further reminds us that these cultures shared significant cosmological assumptions of the ancient Near East. Biblical uniqueness, therefore, does not lie in having anticipated our humanitarian ethics. It lies in something else. Covenant, holiness, land, and religious exclusivity turn violence into a subject of theological regulation. And perhaps the most unsettling phrase in this section is precisely the one with which we began. God walks within the camp. For if the divine presence accompanies the soldier, then war cannot become a holiday for the conscience. The greater the power to destroy, the greater must be the vigilance regarding what we might become. Who has the right to send a society to war? The question seems modern, yet the rabbis realized early on that it was not enough to read biblical wars merely as isolated episodes. They had to be legally classified. Thus, two fundamental categories emerged: Milgemet Mitzvah, obligatory war, and Milgemet Rezhut, discretionary war. Maimonides, in Hilkot Melachim 5:1, includes the struggle against the 7 Canaanite nations and Amalek, as well as the defense of Israel against an attacking enemy, among obligatory wars. In contrast, campaigns aimed at expanding borders, aggrandizing the king, or boosting his prestige fall into the discretionary category. However, rabbinic terminology is not entirely uniform. Mishnah Sota 8:7 preserves a debate between the sages and Rabbi Yehuda regarding the categories of obligatory, war versus war of precept. Why is such classification so important? because the category entails legal consequences. According to Mishnah Sanhedrin 1:5 and 2:4, a discretionary war requires authorization from the Court of 71, the Great Sanhedrin. In Maimonides' codification, an obligatory war does not depend on that same authorization. Personal exemptions also vary. Home ownership, a vineyard, marriage, and other considerations may exempt an individual from certain campaigns, whereas such exemptions vanish in the face of specific obligatory wars. Defense is also linked to pikwach nefesh, the preservation of life, and the commandment not to remain indifferent to the blood of one's neighbor. Yet, one must beware of oversimplification. The laws regarding the rodef, the pursuer threatening a life, do not, in themselves, constitute a comprehensive theory of interstate warfare. Nor do classical sources offer a unanimous formula for preemptive war that equates simply to Article 51 of the UN Charter. The Jerusalem Talmud and later authorities would fuel a far more complex debate. Here, a fascinating principle emerges: institution over charisma. The king, the Great Sanhedrin, and, in certain traditions, priestly consultation create barriers against private or impulsive warfare. Even the king must live under the Torah, as established in Deuteronomy 17. In constitutional terms, the ruler does not receive a blank military check. Yet, we must not pretend that these ancient institutions automatically offer a theory regarding the authority of the modern state. The Great Sanhedrin and that monarchical structure no longer exist in their classical form. What happens before combat? Maimonides expands upon the offer of peace, recounting that Joshua presented three options. Those who wished to leave could do so, those who accepted the terms could do so, and those who wished to fight would fight. And in Hilkot Melachim 6:7, an extraordinary rule regarding sieges appears. One must not completely encircle the city, but rather leave one side open for escape. This tradition, linked to the war against Midian, became one of the most evocative classical texts regarding the possibility of escaping a siege. But again, comparison does not mean identity. A contemporary humanitarian corridor involves legal issues concerning security, consent, displacement, return, and the protection of civilians. International humanitarian law does not simply contain a universal rule to always leave a fourth side open. It does, however, establish obligations regarding precautions, warnings, and humane treatment, depending on the applicable circumstances. Discipline continues during combat. Baal Tashit limits destruction that lacks a legitimate purpose and subsequently extends to property and resources. Maimonides' rule preserves an exit route during certain sieges. Maimonides warns that war, precisely, demands heightened vigilance against cruelty. The law of the Yafat to Ar, the beautiful captive woman, demonstrates that victory should not be understood as a license for unlimited sexual conduct. Even the sanitation of the camp is part of that discipline. And exemptions based on fear combine human consideration with a fundamental military reality. Panic fights too, but on the wrong side. Finally, the aftermath arrives. And here, we must abandon any romanticism. The biblical world permits the taking of spoils, servitude, and the appropriation of populations under circumstances that contemporary law rejects. The tradition introduces significant restrictions. It limits certain forms of exploitation, requires the release of captive women in specific circumstances, and expands the principle of Baal Tashit. However, these internal limits are not equivalent to the Third and Fourth Geneva Conventions. Therefore, we must resist two opposing errors. Claiming that the Torah permits absolutely everything during war is false. There are real legal restrictions. Claiming that the Torah already fully embodies international humanitarian law is also false. It projects our own categories onto an ancient system that permitted practices considered inadmissible today. The historical lesson is more an ancient system that permitted practices that are unacceptable today. The historical lesson is more interesting. Rabbinic tradition sought to transform war from an act of power into an act subject to classification, authority, procedure, and limits. And that insight deserves to remain with us. When a society decides who can order a war, it is also deciding who will have the power to send others to their deaths. Precisely for this reason, the more terrible the decision, the less it should depend on the impulse of a single person. At this point, a fundamental shift occurs in our research. Until now, we asked, what does the law mean? Modern biblical criticism adds another, potentially explosive question. When, why, and for whom was it written? Much historical critical research places a core of the Deuteronomic Code in the late monarchic period, often linked to the 7th century BCE and the reform attributed to King Josiah. It also acknowledges exilic and post-exilic developments, although the specific dates and strata remain a subject of debate. Moreover, a law incorporated at a later stage may preserve much older traditions. A fascinating element is the resemblance between the language of exclusive loyalty found in Deuteronomy and that of Neo-Assyrian treaties. According to one influential interpretation, Judean scribes appropriated imperial language. The message was revolutionary. Israel's absolute sovereign is not Assyria. It is YHWH. The laws of war, then, also play a role in a political theology concerning identity, land, and worship. However, we must distinguish between legal text and historical practice. The fact that Deuteronomy formulates a law does not automatically prove that the law functioned as a military code applied literally. Ancient Near Eastern codes could regulate, but they could also teach justice, legitimize authority, and construct memory. This is particularly important regarding the Harem, ban of total destruction. Literarily, the book of Joshua presents a devastating conquest. Yet, archaeology does not confirm a total, simultaneous, and uniform conquest of Canaan of the sort a superficial reading might suggest. That does not render the text innocent. An ideology can outlast the event it purports to describe by a long margin. Laura Quick offers an extraordinary example involving military exemptions. House, vineyard, and wife appear in Deuteronomy 20. In Deuteronomy 28, they reappear as a curse, building but not inhabiting, planting but not enjoying, betrothing but losing. According to Quick, removing these men from the army would prevent signs of frustration and curse from accompanying the troops into battle. The rule was simultaneously social, ritual, and psychological. Something similar applies to trees. Empires could destroy orchards as a form of economic punishment and a demonstration of dominance. In contrast to that world, Deuteronomy 20 forbids the destruction of fruit trees during a siege. Yet, let us not invent modern environmentalism. Non-fruit-bearing trees could be put to military use. The distinction lies between necessity and wanton devastation. Feminist critique introduces another essential question. Who has a voice? In the story of the captive woman, she weeps, but he captures, desires, incorporates, and eventually releases her. The text limits male power without establishing equality. That is why some scholars speak of forced marriage or sexual violence, while others emphasize that the legal sequence delays the relationship and restricts immediate exploitation. Captivity, in any case, deeply compromises the possibility of free consent as understood by our standards. And so, we return to Harem and Amalek. Scholarly critique has interpreted Harem as sacrificial language, military hyperbole, a program of religious separation, or a retrospective construction of identity. Yet, explaining the literary genre does not erase the phrase, leave no soul alive. Amalek presents another danger, transforming a historical enemy into an eternal one. Remembering can safeguard identity, but indiscriminately casting contemporary adversaries as Amalek can turn political conflicts into metaphysical wars. Academic analysis must therefore preserve all these tensions. Deuteronomy relatively humanizes certain aspects of warfare, yet its protections are particular rather than universal. It limits power, but it also sanctifies specific acts of violence. It preserves diverse voices within the canon, and subsequently, entire generations will reinterpret those voices. Historical criticism can explain how a text came into being. It cannot decide for us whether that text is morally acceptable. For to understand is not to justify. And perhaps therein lies the reader's most difficult responsibility, knowing the past well enough not to falsify it, while possessing enough moral awareness not to remain its prisoner. Now we can make the most delicate comparison of the entire class. What happens when we place biblical laws of war alongside contemporary international law? First, we need to distinguish between 4 systems. Jus ad bellum, or more precisely, jus contra bellum, asks when a state may resort to force. Article 2.4 of the UN Charter prohibits, as a general rule, the threat or use of force against other states. Key exceptions include self-defense against an armed attack, recognized in Article 51, and measures authorized by the Security Council under Chapter 7. The second level is *jus in bello*, international humanitarian law, or IHL. Here, an extraordinarily important distinction arises. IHL regulates how warfare is conducted, regardless of who started the war. Even those fighting legitimately in self-defense remain subject to limits. Having a just cause does not make every means of fighting just. The third level is international criminal law. The Rome Statute establishes, subject to specific legal and jurisdictional requirements, individual liability for genocide, crimes against humanity, war crimes, and the crime of aggression. This encompasses conduct such as intentional attacks on civilians, torture, pillage, hostage-taking, and certain forms of sexual violence. Liability must be proven on an individual basis. An entire people is not legally convicted simply for belonging to a group. Finally, there are human rights, which remain relevant during conflicts, although their interaction with IHL depends on the context. Where does this system come from? Not exclusively from the Bible. The Torah belongs to a much broader history of civilizations that developed restrictions regarding warfare, captives, the wounded, messengers, and protected sites. Modern architecture, in this field, has concrete institutional milestones: the Liber Code of 1863, the Geneva Convention of 1864, St. Petersburg in 1868, The Hague in 1899 and 1907, the 4 Geneva Conventions of 1949, and the additional protocols of 1977. Its operational principles include the distinction between military targets and the civilian population, proportionality regarding expected incidental civilian harm, feasible precautions, humanity, military necessity within legal limits, the prohibition of superfluous suffering, and the protection of the wounded, prisoners, medical personnel, civilians, and specific assets. Now, let us compare this with the Torah. Bal Tashet, limits unnecessary destruction, but it is not identical to the contemporary protection of civilian property or the environment. The offer of peace in Deuteronomy chapter 20 limits violence, but presupposes subordination, not a sovereign peace between equals. The captive woman receives certain protections within the ancient system, yet that regime does not meet contemporary demands regarding consent and sexual freedom. Deuteronomy chapter 24, verse 16 individualizes punishment within its context, whereas contemporary law develops a universal architecture of individual liability. And the collective mandate against Amalek proves incompatible with modern principles when interpreted as the destruction of a group based on its identity. Thus, the great question arises: did humanitarian law originate in the Torah? The rigorous answer is not directly, exclusively, or institutionally. Yet we must not deny its place within a much broader intellectual genealogy. Early modern European jurists were familiar with and utilized biblical and Jewish materials. Hugo Grotius, for example, drew upon biblical sources when discussing war, devastation, and necessity. Charles Lieben has specifically studied the presence of Hebrew sources in the works of authors such as Gentili, Grotius, Selden, and Pufendorf, without equating that intellectual influence with a direct lineage to modern international law. The formula we must remember is simple. The Torah is a moral antecedent and a text of reception. Grotius represents one of the intellectual bridges. However, modern humanitarian codification emerges from military, diplomatic, and humanitarian processes, particularly since the 19th century, and acquires legal force through treaties, custom, and other sources of international law. That is why there are 4 decisive structural differences. The Torah is covenantal and theocentric. IHL is positive international law. Deuteronomy distributes protections based on ancient categories of people, gender, and territory. IHL aspires to protection based on legal status and common humanity. Biblical warfare may be linked to land, chosenness, and divine judgment, Modern humanitarian obligations apply regardless of the justice of the cause. And finally, the institutions differ. King, priesthood, and tribunal in one system, states, treaties, custom, and tribunals in the other. Therefore, comparison is legitimate. Equating them is not. The history becomes much more interesting when we stop trying to prove that our ancestors already thought exactly the way we do. The real question is how different generations learned, little by little, an idea that remains urgently necessary. Even in war, power needs limits. That's all for today's class. Shalom, shalom.